Straight ahead on Law&Crime Daily, the murder of Nipsey Hussle.
March 31st, 2019, at about 3:20 in the afternoon, there was an explosion of violence.
Eric Ronald Holder Jr. shot and killed Nipsey Hussle.
Opening statements are presented in the trial of Eric Holder, plus a civil trial over a Florida dog who was shot and killed.
Is the image of her death burned in your memory forever?
Yes.
Candy, the dog's owner, takes the stand. And Danielle Redlick's trial for the murder of her husband.
Michael Redlich bled out within 5 to 6 minutes. Is that correct?
That's what I understood.
Why this rebuttal witness testimony is so important to the case. But first,
a lot of Amber's story didn't add up, and the majority of the jury felt she was more the aggressor.
Hear from a Johnny Depp Amber Heard juror for the first time. Law&Crime Daily, covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm your host, Brian Buckmire. We're getting word from a juror for the first time since the monumental verdict was handed down in the Johnny Depp versus Amber Heard trial. Millions of viewers watched the verdict handed down right here on Law&Crime Network and the gavel-to-gavel coverage of the trial before that. Actor Johnny Depp sued ex-wife Amber Heard for $50 million, arguing Heard defamed him in her 2018 Washington Post op-ed about domestic abuse. Heard fired back with a $100 million countersuit, doubling down on abuse claims. After weeks of testimony, including from both Depp and Heard, the jury awarded Depp $10 million in compensatory damages and $5 million in punitive damages. Heard also won part of her countersuit when she was awarded $2 million in compensatory damages and nothing for punitive damages over comments made by Depp's attorney, Adam Waldman. For the first time since the verdict, a juror gives his take on the trial in an exclusive interview with ABC News. The juror's face and voice were not shown, but instead quotes from his interview were outlined. The male juror said he felt Depp was more credible than Heard, and though the relationship may have been toxic on both ends, Heard's claims did not have enough support.
The crying, the facial expressions that she had, the staring at the jury, all of us were very uncomfortable. She would answer one question and she would be crying, and 2 seconds later she would turn ice cold. Some of us use the expression crocodile tears. He said, ultimately, what I think is truthful was that they were both abusive to each other. I don't think that makes either of them right or wrong. But to rise to the level of what she was claiming, there wasn't enough or any evidence that really supported what she was saying.
Later in the segment, Law&Crime founder Dan Abrams commented on the juror's interview, saying it appeared as though Heard's testimony was rehearsed.
I said there's a danger if she's looking at the jurors too much. That could be a problem. It can seem like she's acting, like it's over-rehearsed. Because, yes, a lawyer will tell a client, try and make sure you look over at the jury, make sure that you recognize them. But I thought she was doing it too much. Every question she was asked, she would pause, she would turn over to the jury, and she'd begin her answer. And it's clear that at least this juror felt that that was rehearsed.
Joining us today is Texas plaintiff attorney Katherine Lizardo and co-host Terri Austin. Katherine, let's start with you. When we're talking about this case, what was your reaction to Amber Heard's testimony and how that played out?
My reaction there is I said repeatedly that when I was watching her testify, the moment she stepped off the stand, I think she already lost the case because of her credibility factor. When she testified, we already saw Johnny Depp, and after he got off the stand, I mentioned that I think he already won the court of public opinion, and that's true in the social media sense. But Amber Heard, the way she testified did not come across as credible. And as what the juror was saying, she kept on looking at them in a very unusual, weird way, very unnatural, the way you would speak. It's almost condescending at some point how she was just staring at them and telling them her story. So with this juror's comment, it shows that that didn't work out.
Now, Terri, you've been saying this since day one in terms of her inflection and the way that she's been acting. What did you think about her comments and Dan Abrams as well?
You know what? There are three scenarios to prepping a witness. You can be over-rehearsed, you can be under-prepped, or you can be well-prepared. This is definitely an example of where she was over-rehearsed. And I get it. She is an actor. It was probably hard for the lawyers to keep the acting from coming into the testimony, but it was way too much. And one of the other things that the attorneys should have done is listened to what she said when they were prepping her. If it did not sound credible, then they need to fix that. And here they allowed her to get on that stand, to be over-rehearsed, and to say things that the jury was never going to believe.
All right, it seems like the jury has spoken at least one in some anonymity. Thank you both. Still ahead on Law and Crime Daily, the plaintiff takes the stand in Florida's Candy the Dog civil trial. But first, closing arguments inch closer in the case of Danielle Redlick. Hear from a rebuttal witness after this. Welcome back. Both sides rest in a case of Florida versus Danielle Redlick, the woman accused of murdering her stepdad turned husband. Redlick is charged with second-degree murder and evidence tampering for the murder of her husband, Michael Redlich. Redlick claims she killed him in self-defense when she stabbed him in 2019. The two had been married for nearly 20 years and had 2 children together. Defense attorneys say the couple's relationship had a history of abuse and cheating. The couple had also reportedly filed for divorce by the time of Michael's death. 911 calls reveal Redlick initially told dispatchers that Michael stabbed himself and had a heart attack. Investigators say she waited several hours before calling for help the night of his death. As part of its rebuttal, the state called the case's lead detective, whose testimony differed from the medical examiners.
You attended the autopsy of Michael Redlich in this case, is that right?
That's correct.
And you spoke with Dr. Zadovich.
That's correct.
And she was the medical examiner who conducted the autopsy of Michael Redlich.
Yes, that's correct.
And you had a conversation with Dr. Zadovich, didn't you?
Yes.
And she told you that Michael Redlich bled out within 5 to 6 minutes. Is that correct?
That's what I understood.
That he died within 5 to 6 minutes of the stab wound. Is that correct?
That's what I understood.
On the next episode of Law and Crime Daily, we'll break down closing arguments from both sides. Terri, why is it so important that the lead detective testify saying Michael Redlich died within 6 minutes, especially when it didn't seem to match up with the medical examiner's testimony?
Credibility is everything in any trial, and here the jury instructions actually said if there's a prior inconsistent statement, then the jury can consider that. And it was really important that lead detective talk about the fact that the medical examiner first told her that, in fact, he bled out in 5 to 6 minutes. That's critical because that means that we know that the defendant didn't just wait around until he passed, that it was 5 or 6 minutes. And then when the medical examiner got on the stand, she really tried to backtrack and she said, well, you have to observe. So it was critical that that information got in, and kudos to the defense for getting that in there, for having that detective admit that.
Yeah, it's going to cause a little confusion for the jury there and maybe a little reasonable doubt. Katherine, what did the lead detective give the prosecution and defense to argue in their summation, and who had more to use based on this testimony?
The defense definitely has more to use in this testimony because then they can question, as Terri mentioned, the credibility of the witnesses that the state put on. What's interesting too in here is when we were seeing how the prosecution was questioning Danielle Redlick, he was very intimidating and almost over the top in terms of using the juror in Amber Heard's case when the juror mentioned that Amber Heard's legal team was sharp on the elbow. Here, the prosecutor, when he was questioning Danielle Redlick, he even had his arm on his side and towering over her, seems like it, and did not look appropriate in terms of being too condescending. So I think that the defense will definitely use that a lot as well, in addition to the lead detective.
Absolutely. There's a reason why a lot of people say Camille Vasquez cross-examining Amber Heard made a lot more sense than Ben Chu, and that's, I think, the point that you're making. And in Jacksonville, Florida, defendant Alan Wade offers an emotional apology at his resentencing trial for his involvement in the murder, which happened more than a decade ago. Wade, along with 3 others, Michael James Jackson, Tiffany Cole, and Bruce Nixon, were convicted in 2008 for their involvement in the 2005 murder of Reggie and Carol Sumner, a couple who were buried alive after being robbed. A jury found the four guilty of digging a hole in a remote wooded area in Georgia before kidnapping the Sumners, stealing from the couple's home, then forcing them into the trunk of their own car. They forced the Sumners to share bank account information before burying them alive. 3 of the 4 were given the death penalty. Wade and Jackson are being resentenced separately after a change in Florida law which requires a unanimous jury decision for the death penalty. Wade took the stand on Wednesday, not for questioning by attorneys, but to give an apology to the family of the victims and his own.
Nothing I say here today is meant to justify, excuse, or defend my cowardly crimes. Reggie and Carol, if there's a window or a connection to the afterlife or some sort of cosmic consciousness, and I know you can see the tremendous regret and shame in my heart.
Coming up on Law and Crime Daily, opening statements are presented as Nipsey Hussle's accused murder stands trial. Plus, Candy the dog's owner takes the stand to describe the emotional moment when his dog was shot and killed. Welcome back. A dog's owner takes the stand in a civil trial out of Florida as he works to bring justice for the death of his beloved companion. A dog owner, Rodney Jacobson, filed a civil suit against Zach Deaterly, saying Deaterly wrongly shot his dog, Candy. It happened on Deaterly's father's property back in 2016. Jacobson, who had permission to store his boat on the property, was cleaning it. Candy was off leash when she approached Deaterly. He says the dog was in an attack stance. After that, Deaterly pulled out his revolver and shot the dog twice. The Sarasota County Sheriff's Office says Deaterly was not charged because he had a permit to carry the weapon. They say he was also within his right to use deadly force because he feared for his life. Jacobson says Candy had no history of aggression and was only barking at Deaterly because she didn't recognize him. On Thursday, Jacobson took the stand. He testified what happened the night Candy was killed.
I heard 2 gunshots and looked over at Mr. Deaterly, and he had a revolver in his hand, and he had fired 2 shots at Candy. I was in disbelief. I said, "Did you just shoot my dog?" And he said, "Damn right I did, and I'll do it again."
How did you find Candy?
Well, I followed her. I saw where she was running towards the boat, so I ran after her, and when I got closer to the boat on the dock and then on the gunwale of the boat and then in the cabin of the boat where she ended up, there were, trail of blood.
Were you in fear during that situation?
I was in fear that he had not put his gun down and was still brandishing it around while I was going after Candy.
But were you fearful during when he was firing the weapon that it could have been turned on you?
Yes.
Terri, Jacobson sued for intentional infliction of emotional distress. What kind of damages can he recover under that cause of action?
You know what? This is one of my favorite causes of action. Under Florida law, you have to prove 4 things: that it's deliberate, it's outrageous, the conduct caused the emotional distress, and the distress was severe. So you have to demonstrate those things. And you do that by asking whether or not he sought medical treatment, whether or not any of his relationships suffered. That's why you saw the plaintiff asking all of those questions to the individual on the stand, to the plaintiff on the stand. And so he answered those questions. The jury can then determine, what are your actual damages? Did you have to pay for this? Did you have to pay for that? And also the jury can give you an award for that emotional distress. Really, the attorney should try to set a number, but if you don't, the jury can set a number themselves. So it's a really broad, difficult one to prove, but a broad cause of action.
Yeah, difficult to prove, and any dog owner will say the same. What number do you put on a beloved 4-legged companion such as Candy? But Katherine, Jacobson hopes that winning this case brings about criminal charges. But is that likely, and how would that work?
Not necessarily, because the burden of proof for criminal cases are much higher, as we know, as opposed to civil cases. And so winning here in the civil case will not automatically result in criminal charges. Now, what could happen, though, is the evidence that have been presented in the civil trial, they can use that for the criminal case. I know that there were no criminal charges filed against Deaterly for shooting the dog because the officers felt that he was within his rights to shoot the dog because he was on the dog was on the property, and also he said he feared for his life. Now, what comes out in the civil trial will definitely be critical if there's going to be a future criminal charge case.
All right, we'll see how this case continues and how it's resolved in the end, and maybe it does, maybe it doesn't go to that next level of a criminal case. When we come back, the murder of Nipsey Hussle. Opening statements are presented as Eric Holder Jr. stands trial for the murder. Welcome back to Law and Crime Daily. Opening statements are presented in the long-awaited California murder trial of Eric Holder Jr., a man charged with murder in the death of rapper Nipsey Hussle. Prosecutors say Nipsey Hussle was gunned down by Holder outside the rapper's Los Angeles clothing store in March 2019. In addition to his music career, Nipsey Hussle was reportedly dedicated to supporting youth and the community where he grew up, the same community where he died. After 3 years of delays, Holder is facing a jury for the first time on charges of first-degree murder, 2 counts of attempted murder, and assault with a deadly weapon. Police say a dispute broke out between the two men before Holder left the store, then returned with 2 firearms. A medical examiner found Nipsey Hussle was shot at least 10 times, with the bullets piercing his lungs and severing his spinal cord. During opening statements Wednesday, prosecutors told jurors Nipsey Hussle was killed in a calculated and premeditated attack. Jurors saw a video showing the last seconds of Nipsey Hussle's life.
March 31st, 2019, at about 3:20 in the afternoon, there was an explosion of violence. At that place and at that time, the world lost Ermias Joseph Ascadon, better known to the world as Nipsey Hussle. Eric Holder is shooting from a .40 caliber semi-automatic handgun and a revolver. He fires at least 10, possibly 11 shots. After he's done shooting, he walks over, he kicks him in the head, and then he runs back toward the alley.
Holder's defense attorney says his client doesn't deny shooting Nipsey Hussle, only that it was not a premeditated attack.
On March 31st, 2019, Eric Ronald Holder Jr. shot and killed Nipsey Hussle. A bullet accidentally hit Mr. Latham, and Mr. Villanueva may have been grazed. We're not sure. And the provocative act in this case was that Nipsey Hussle had made an accusation against Mr. Holder that he was a snitch. That so inflamed and enraged Mr. Holder, the evidence will show that without thinking, and a few minutes later, a mere 9 minutes or so later, Mr. Holder returned and shot Mr. Ascadon.
All right, so we heard it there. Defense attorney doesn't seem too confident in his own opening statements, but let's kind of dissect it there, Katherine. Holder's defense is saying this isn't premeditated because this 9 minutes wasn't enough of a cooling off period, and he was still in the heat of passion, a legal term, trying to drop this down from murder to manslaughter. But does that make sense?
You know, when he's trying to argue the 9 minutes, that's what we call a question of fact. As to looking at other cases, what has happened, what has been concluded as to whether 9 minutes is enough as a cooling off period for premeditated. But if you think about it using your common sense, 9 minutes is a long time. And one way to do that is take out your watch and really put that in a timer for 9 minutes. That's a long time. When we are on break here for the show, that's about 3 minutes, and it feels like a long time. Now multiply that, by 3. That's, as you can imagine, you will feel the length of time. Also, the key there is he left to get guns and then come back and shoot him. The act of actually leaving and going through that exact motion of getting the guns, coming back and shooting him, that will definitely be played out here step by step during any examination of the shooter here.
Yeah, supposedly he also left and finished some chili fries. I mean, you sit down and eat chili fries, that's enough time to cool down in my mind. So we'll see how that plays out when the testimony comes out. But Terri, Nipsey Hussle and Holder have ties or alleged ties to the Crips. And the defense is saying that in gang culture, being called a snitch is enough for a heat of passion defense. How much of gang life is going to be brought into this trial, and is that believable?
I think a lot of gang life will be brought into this trial. I hope not, though, because that's not what this trial is about. As Katherine said, it's all about whether or not he came back. It was premeditated. He knew what he was going to do. He got those guns. So I hope the gang doesn't come into it.
All right, we'll see how it plays out. Thank you both. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.